right,
Looks like we got it set up.
I was hoping.
But it's not.
Yeah, unfortunately, that would have been perfect.
Why don't you have your selfie stick here? Come on.
I
What
know.
about these? Who's these? Well,
I thought.
They're just not heavy. They're not heavy enough.
We had the remote.
could you use the drawer? No, it's not work. That's it, the drawer.
Yeah.
It's too far away.
Don't breathe.
Alright. I'll tap record and then we should be good to go.
Yeah, it's fine. It's 2:41, so you can, yeah, it's taking 10 minutes, so it's all good. Right. You can play your role, it's fine. Yeah, right, no, I understand. I mean, you can, I would do it. That's fine.
How did we do this before?
Yeah, I think there's like a small like ridge. It's on the power button. That's I think what's kind of doing it to us. There we go. I mean, maybe we move it a little bit this way, but other than that, we'll be. Let's see.
Supposed to do something?
Oh, just, if they give you the one-page
Yeah.
plan to discuss, just give it up to me.
Okay.
All right, Godspeed, have fun.
Thank you.
Thank you. You look nice then.
That one is recording. I don't know if the other two are.
I know this one's recording.
That one has the green lights on. The guy told us the green light.
All right, so green light means recording.
That's what he said.
Okay. And that one's
Green
recording.
light is-
Okay. So we are recording. We're live.
I sound like a child on recording, so.
So do I. Okay.
Tell me when you want to start.
I'm ready. Oh, we might have to talk up a little bit.
Okay, just remind me, because I kind of mumbled, so, but I'm ready.
Okay.
All right. Good afternoon. My name is Michael Rust, and I'm going to be serving as the mediator today. Who do we have?
My name is Benjamin Walker. I'm of counsel for Dr. Idea.
I'm Warren Glish, and I'm here on behalf of Dr. Lewis.
And we're all okay with using first names?
Yeah.
Sure.
All right, wonderful. And please feel free to call me Mike or Michael. Either one works.
Of course.
So my role today, as you are both aware, is to serve as the mediator to facilitate the discussion, to see if we can find some kind of resolution to the dispute that brings us here today. I know very little about what brings us here in terms of what the actual probably get started this,
Okay.
but yeah, during the course of your conversation, I will be taking some notes in order to make sure that I get up to speed. Um, Mediation is confidential, and so all of my notes will be destroyed at the end of the mediation. I don't keep a file. The only thing that I report back to the court is whether or not there was an agreement. That's it. Nothing else goes back to the court. The only other issues that could come about would be if there was any type of threat of imminent harm or instance of child or elder abuse, which I would be required to report. Being as we're all attorneys in the room, I don't expect that that's going to be an issue here today, but it's part of my spiel, so I'm going to say it. I do try to run my mediations relatively loose, but because I am going to be listening to both of you and taking notes, I really do ask that everyone, one person speak at a time. Interrupting and trying to talk over each other isn't going to get us anywhere today. So that, that it is really my one ground rule for mediation is that only one person speak at a time. Being as both of you are here on behalf of your clients, let me just ask the beginning question, because I think that's going to be important. Do we both have authority to settle the case without your client here today?
I do.
Yes? Okay. All right, so in terms of starting off, I like to start with the plaintiff or whoever brought the issue forward. And so I believe that is...
It was actually Dr. Lewis that brought it.
Dr. Lewis? Okay. And so, Maureen, if you could kind of explain to me...
Morgan, sorry.
Did I write Maureen? I
I
did.
mumble.
My apologies, Morgan. So if you could explain to me a little bit about what brought the issue forward, and then we can discuss how to move forward.
Of course. So my client was hired by Ben's client, Dr. Idea, to basically run a research facility exploring genetic testing and DNA testing. I don't really know the exact terms. I'm not a scientist. But basically what happened was the first thing my client needed to do was go to New York and get a license to be able to create the facility in New York. And New York did not allow my client to get a license without paying $100,000. However, he was given a strict limitation on the money he could spend, and he had already spent enough money that he only had $75,000 left. So he tried to amend the application, and he didn't discuss that with Dr. Idea due to the fact that he has a lot of expertise in this area, and figured that he'd be able to get the application amended, and he wasn't able to do so. So he wasn't able to get the license for New York, and he was fired by Dr. Idea, just fine. The issue here is that in the contract that Dr. Idea and Dr. Lewis had, my client was supposed to be able to get 6 months of payment once he was terminated, and he did not receive that payment.
And the 6 months severance is per contract?
Oh yeah, the 6 months notice, it's required for termination. He has to be required basically for 6 months, and he has to be terminated for cause. I don't believe, and he doesn't believe that he's terminated for cause, and he is entitled to that 6 months payment.
Okay. What, in order to talk kind of more round numbers as opposed to 6 months, do we know what that 6 months payment is?
Yes, sorry, it's $60,000.
Okay. So Dr. Lewis was hired by Dr. Idea's company to do scientific research, which was, that facility was required to have a license by the state of New York. And the cost for that license was about $100,000. And based on the other startup costs, the remaining funds for Dr. Lewis was only $75,000. And because Dr. Lewis was unable to obtain the license, Dr. Idea's facility terminated Dr. Lewis, and now we're here because of that termination, and what Dr. Lewis is seeking is the 6 month severance according to the contract, or $60,000. Is that a fair recap of where we are?
Correct.
Is there anything else that you feel needs to be be added at this point?
Not
Okay. Benjamin? Tell me why you were here.
Sure. All this came about because Dr. Idea was intrigued by genetic testing. Dr. Idea is a very successful doctor and wanted to break into the genetic testing field with such a large interest surrounding this area at this time. So Dr. Idea searched for somebody who could run this facility, who could get this this laboratory started up, because Dr. Idea is a very busy woman. She has a number of projects, and she just simply did not have the time to invest into starting up such a laboratory. So after hiring a number of very qualified candidates, she chose who she thought would be best suited to take this position, and she chose Dr. Lewis. Dr. Lewis had very high credentials. He's an amazing doctor. We wholeheartedly believe that he had what it took to get this genetic laboratory up and running. So about a year ago from this time, Dr. Lewis attempted to obtain licensing for this genetic laboratory, and Dr. Idea stated in the beginning that he only wanted to spend $250,000 in startup costs to get this laboratory up and running. So Dr. Lewis went and bought the equipment to have at the genetic laboratory. Dr. Lewis began trying to obtain this application, but as Morgan stated, Dr. Lewis had already spent about $175,000 to obtain a facility and equipment for this genetic laboratory. So that resulted in $75,000 being what was left from the original projection of $250,000. So my client was unaware that to obtain a license, the New York board that determines licensing of these facilities, they require approximately $100,000 in reserve cash flows so the research lab can be sustainable, to avoid any foreclosures or anything like that to put the laboratory out of business. And Dr. Lewis failed to communicate that with Dr. Ideas. Dr. Ideas had no knowledge that he didn't even have the opportunity to think about giving Dr. Lewis the opportunity to put forth this $100,000 for license. Dr. Lewis simply ran with the idea that that he could potentially obtain this waiver from the licensing board to operate the facility with only $75,000 in reserves. And after time, and after Dr. Lewis amended his application for this waiver, the waiver was ultimately denied by this licensing board. And because of this, Dr. Ideas had to close the genetic laboratory because he couldn't keep funding this failed project. So because this laboratory did not obtain licensing, which was one of Dr. Lewis's main priorities in being employed. Whenever he was employed, his number one, job description, or terms of employment, was to obtain licensing for this facility. And because Dr. Lewis failed to communicate with Dr. Ideas about the additional funding, this resulted in the application to be denied. And because of this, the research laboratory failed. And under the contract, Dr. Ideas terminated Dr. Lewis's employment for cause, and that's essentially why we're here today, is that Dr. Lewis, or Dr. Ideas terminated Dr. Lewis's contract. It was for cause, and now Dr. Lewis is attempting to receive a severance package, which under New York state law, Dr. Ideas did terminate Dr. Lewis's employment for cause.
Okay. So your client, Dr. Idea, is kind of a big thinker and wanted to add this new genetic testing laboratory to the menu of services that she offers. And after looking at a lot of other qualified candidates, she settled on Dr. Lewis. And Dr. Idea had about $250,000 in startup money for this facility, from which Dr. Lewis bought equipment and secured a location, and a lot of the other startup costs, leaving only about $75,000 in cash reserves. And when Dr. Lewis then went to obtain the license from New York, the issue was that the state required $100,000 in reserves, and so ultimately a waiver was sought but was denied, and Dr. Idea had to close the genetic laboratory service. And it sounds to me like Dr. Idea is frustrated because when she reached out to Dr. Lewis, she thought that Dr. Lewis's #1 job was to obtain licensing for the facility. And with the idea that he did not obtain the license, he was terminated, and it's your position that that is a for cause under New York law, correct? Is there anything else that you wish to add at this point?
I don't believe so.
Okay. Morgan, is there anything you'd like to add after hearing what Benjamin had to say?
No.
Okay. So, really looking at the list of the facts as you have presented them, it seems like you're both pretty much in agreement. There's not a whole lot of disagreement as to the facts. There may be disagreement as to the application of the law and whether or not they should be deemed a for-cause termination. But I think for the purposes of mediation, obviously that's not really going to be our discussion here today. Our discussion is going to be, now that we have a good understanding of the facts, what are we going to do next? And so, I guess to understand a little bit of where we're going to go next, can I ask, has there been any settlement offers or discussions had to date?
There have. Dr. Lewis did ask for this $60,000, and Dr. Ideas, with the business failure, he did not want to put forth any more money into this business venture, and he used this litigation as part of his business venture. So $60,000 was requested by Dr. Lewis's party, and Dr. Ideas did not want to pay anything. So while there has been a first offer, I think, from both sides, that was kind of where we're at.
So the offers have been 60 and 0?
Correct.
Okay. Just so I know exactly where we are. Okay. And so, with this type of situation, with neither of your clients here, I feel like I can be a little bit more blunt in my question asking. I don't need to beat around the bush and quite be so nice, because neither of you really have the emotional investment in this, for lack of a better term. You're both hired guns in this fight. So, I mean, we're looking at this situation. We have two numbers of 60 and 0, and there really hasn't been any movement from that. Do we want to start this with a brainstorming session to discuss potential ideas? Do we want to just dive right into somebody interested in making an offer? What do we want to do here?
I think it would be best to possibly just kind of brainstorm and just, I guess, dive a little bit deeper into things. You know, my client put a lot of money into this business venture. It's failed, and yes, he's a little angry about what happened. And I would like to, from my client to Dr. Lewis, I would sincerely like to apologize for the tense emotions that has occurred since business operations started going downward. A failure of a business is hard on a lot of people, and obviously this is no reason for my client to vent his anger towards Dr. Lewis, but it's a very tense situation. But we really did want to sincerely apologize for any resentment or any anger that was pushed forward towards Dr. Lewis. We understand he was a very qualified candidate. You know, that is why we hired him. Dr. Lewis was a very qualified candidate. You know, it's just our position that that there is this lack of communication. And because of this lack of communication, things slipped through the holes, and it resulted in the licensing not obtaining approval.
I'll pass it along to my client. I appreciate the sentiment on behalf of my client. However, I think it needs to be understood that my client is also very angry. I mean, my client left behind his entire career in Chicago to come out here, and it was a risk to him as well. And I feel like he feels that that's not really being understood, that now he doesn't have a job, and he's in New York where he doesn't have any of his prior references and relationships with people to get a job, and I mean, he now is not being paid for the job he feels that he did adequately. So he no longer has any money, he has no job, and he's trying to find a job, and he's only 4 years out of retirement, I believe. So, he's very upset. He's upset that this didn't work out. He's upset that he feels like he wasted his time and energy, and now he's not going to be paid for any of the work that he did, and that's just not fair to my client.
So you were mentioning how your client was angry that he moved out here, he felt like he took a risk, and now he essentially has nothing to show for it. You were mentioning how he was searching for a position. Has he applied for any places? Has he obtained offers from other facilities in the New York area?
He hasn't been offered anything. He hasn't been able to find anything, and this case isn't exactly helping his chances right now.
And again, I apologize that we have to be tied up in this. We never wanted the relationship to sour to this point. I mean, when Dr. Ideas began this business venture with Dr. Lewis, Dr. Ideas thought this would be a long-lasting partnership into a successful venture. And when business ventures fail, there is a lot of built-up tension, and that's why my client would really like to apologize for the anger that has came about from this failed venture. Now, does Dr. Lewis have any interest in potentially starting up his own laboratory? I mean, I know you stated that he didn't have any, he is without a job and he's short on funds. And does he have any savings or any aspirations?
No, this time my client hasn't mentioned anything to me about starting up on his own.
Gotcha. I guess in that regard, would Dr. Lewis potentially be interested in continuing a potential business relationship with Dr. Ideas? Because Dr. Ideas, while there was this failure in communication, Dr. Ideas fully believed that Dr. Lewis was more than capable to perform this job.
I mean, as far as keeping a business relationship with your client, I'm not sure. I know my client very much wants to find a job, but I think at this point there's going to be a lot of trust issues because my client feels that he upheld his part of the job and his part of the deal, and he doesn't understand why your client isn't going to uphold hers.
So why does Dr. Lewis feel that Dr. Ideas didn't hold up to his part of the agreement? Because Dr. Ideas, I mean, compensated Dr. Lewis above what is typically called for, because both parties understood this was a risky venture and this could fail whenever it was initially started.
My client does not feel that they were compensated above. I mean, again, my client had to leave his entire business and entire career reputation and professional career behind in Chicago and move out to New York to help Dr. Idea with this venture. My client was given money to set up a laboratory and get the equipment, which he did, and he did his best to obtain a license based on his own expertise. I mean, yeah, he should have maybe talked, he knows he should have probably talked to your client, but your client also gave him a strict financial limitation of $250,000, which just wasn't going to work to get a license. So he has 30 years of experience. He used that to do what he thought was going to work and amend the application to try and only pay $75,000. It was rejected, but it wasn't that my client just didn't do his job. He did everything he could. And so he feels that he did what he was hired to do, to diligently try to set this up. And for the most part, he set it up. He just was not able to return the license. So he feels that he should be compensated.
And I guess the one thing Dr. Ideas was just wondering was why there was kind of this lack of communication. Is there any reason from?
My client, though now regrets that he did not talk to your client, does feel that he maybe should have. He just didn't think it was worth it because he was given such a strict limitation of $250,000, and he didn't think that he would be able to get the extra $25,000 from your client. So instead of potentially causing more stress on your client, he wanted to try and do what he in his professional career has seen work, and to amend the application. And he was hoping that would work and be able to have them start their project and cause less stress for your client and for him.
Gotcha. So, Dr. Lewis is currently unemployed, correct?
Correct.
And I don't think anyone is doubting Dr. Lewis's credentials. I mean, he's obviously a highly qualified individual in genetics. You know, Dr. Ideas has a blood testing laboratory that's highly successful, and Dr. Ideas was open to the possibility of bringing in Dr. Lewis to work at this successful blood testing laboratory, and because he is remorseful that Dr. Lewis did come out from Chicago to New York. You know, we do understand that was a big move, and we think, you know, we definitely still believe that Dr. Lewis can be a very valuable asset to Dr. Ideas business ventures. Maybe it would just be more beneficial to both parties to have Dr. Lewis working at an established venture rather than a venture where there's a lot of uncertainty.
And that would definitely be something I'm sure my client would be open to discussing. I can't speak at this point whether or not he would want to necessarily work with Dr. Idea again. My question then would be, what position would Dr. Lewis hold? He was hired to be a director, so would that be a position that he would be offered at this other facility?
What positions has Dr. Lewis held in the past? I mean, did your client communicate that information, or?
No, my client hasn't communicated that information. I know he has a PhD in genetics. I think he worked fairly high up in the research laboratory where he worked before, but I'm not completely sure what position he held.
Gotcha.
I only know he was hired to be a director for this research facility that Dr. Idea was trying to start.
Gotcha. I'm not sure if we would be able to bring him in as a director simply because this is an established venture. You know, we already have employees put in place. but we definitely could bring Dr. Lewis on to perform, to use his past credentials to benefit this blood testing laboratory. So while this position wouldn't necessarily be the same in compensation as what Dr. Lewis was obtaining as a director of a risky kind of startup, but we might be able to come to something close to what he was receiving as director.
I mean, I think that's something that we can definitely discuss. I think we should table that for right now. Because where I'm looking at this is, okay, so if we'll just say that we agree on this potentially, that Dr. Lewis has been working out for Dr. Idea, there has to be some sort of good faith built here by the fact that if my client is going to trust working for your client again and not get, to not get fired for no reason and, to actually get paid the money he's supposed to be getting paid, I mean, I feel like then your client's going to need to show some good faith here to pay at least some of the severance that my client is owed. The big question here for my client is, what is the cause that my client is not getting paid?
I understand that there's some, I guess, unknown from Dr. Lewis as to why he was fired. And Dr. Ideas and I, to determine for cause termination, it is, in New York, it is a four-pronged, you have to have 4 elements to determine for cause termination. And we believe that each element was met according to New York state law and what Dr. Lewis's job objectives were. So these 4 elements are
I know the elements. I know the New York law.
Of course. So, we believe the first element was met when Dr. Lewis's acts would be deemed as an intentional behavior. Second element was met because this behavior caused the business failure, which was.
Did you say the second element?
Yes.
The second element is about
Sorry. It was in his control because Dr. Lewis could have communicated with Dr. Ideas to allow him to determine if he wanted to fund this additional amount before heading on to apply for a waiver.
Yeah, I think that's where we differ in our application of the law, because as far as within his or her control, it's not within my client's control whether or not New York is going to grant him a license. He did his due diligence. As far as it goes from there, it's not in his control whether or not the license gets granted.
And we understand that there is a bit of a idea, or there's a bit of unknown to see if this waiver would have been granted, but Dr. Lewis never even called Dr. Ideas to make this determination. Ultimately, Dr. Lewis is an employee of Dr. Ideas and should report these very important business matters, or at least educate Dr. Ideas to the situation. And because of this lack of communication, it was in Dr. Lewis's control to communicate this issue with Dr. Ideas.
And again, I reiterate the fact that why would my client communicate when he's given a very strict budget? He was given a strict budget. He was told that he's not to go over that budget no matter what. So in his mind, why waste time asking for money he knows he's not going to get and just try to amend it? In his experiences, he's seen this work. He's been doing this for 30 years.
And we understand that, but there is also I'm sure Dr. Lewis has also seen times when this hasn't worked. And when this doesn't work, this results in a failure of the business. So in the large scheme of things, what's $25,000? That's 1/10 of what was initially offered. If this communication was
I mean, if that's the issue, then why was the 250,000 such a strict limit?
Well, when Dr. Ideas wanted to start this business, it's in all, most individuals who are attempting to obtain a return on their investment, and obviously want to cap the amount of, or at least set an original barrier to what is being offered. And while Dr. Ideas initially stated that he didn't want to spend more than $250,000, he didn't even get the opportunity to think if he wanted to invest more into it. He never had this opportunity to even think about it. And that's where we see that, Dr. Lewis intended to not communicate, and, it caused harm to Dr. Ideas' genetic laboratory, and that this harm, it was substantial because it caused the foreclosure, or the failure of this lab. So we understand, unfortunately, that's where we kind of stand, or where we believe that things kind of started going south, but we don't necessarily believe that Dr. Lewis is a unqualified doctor. We still very much believe in his abilities, and we would love to have him on, and we would even be willing to give him more security if he's afraid that that he may get terminated for what he feels is improper.
Are we talking gold parachute here, or what are we talking about?
Maybe we could probably try to hash out a termination clause or something of that nature to go along with this employment, to provide Dr. Lewis more of an assurance that Dr. Ideas, won't just get mad one day and fire half the office. Dr. Ideas isn't that type of person. She is a very caring person. She's in the medical industry, so obviously she's trying to help out and make the world just a better place. But ultimately, the reason why she had to let go of Dr. Lewis was because of Dr. Lewis's actions, and we were not able to obtain this license, and it resulted in the closure of this laboratory.
I guess my other question then is, if this was such a huge deal, why did Dr. Idea wait 7 months to fire my client? The license was rejected 7 months ago. My client was just fired. So I feel like somewhere in that time frame, your lab license wasn't obtained, so for 7 months, you know that this lab isn't going anywhere because it has no license. So my client couldn't even have been given notice that he was going to be fired?
Dr. Ideas didn't really inform me why Dr. Lewis was fired then, or why he was fired recently rather than whenever.
I just find it difficult to believe that if that's the cause of him being fired, why he wasn't fired immediately. If his sole purpose was to get the license and he failed to get the license, why did she wait 7 months to fire my client? That's where I'm having issue with the for cause. Had my client been fired immediately after not obtaining the license, that'd make a little more sense to me. But then he continued to be held as an employee for 7 more months. So what's the cause then after 7 months that all of a sudden, 7 months? For 7 months there was no license, so then where's the cause after 7 months for firing my client?
Well, Dr. Ideas I can't speak, I'm just maybe speculating at this moment because Dr. Ideas really hasn't communicated this information with me. But it's quite possible that Dr. Ideas waited to terminate Dr. Lewis's employment contract because Dr. Ideas could have just simply thought that Dr. Lewis was trying other avenues and ventures to obtain this license, and after a long, or after a certain amount of time and having to pay Dr. Lewis, or pay Dr. Lewis to work on the license and getting this laboratory running, maybe he just thought that he could not invest, or she cannot invest any more money into this business venture. So, I mean, as I stated.
Well, going back to if they couldn't do the any more money thing, then why would it matter if my client asked us $25,000?
I think we're starting to cycle. This is where I like to call it the spiral of death, where we just keep circling around the same thing until we get stuck. And so what I'm going to do is I'm going to caucus with each of you, have an individual meeting. I mentioned earlier the confidentiality of mediation, and during the caucus there's an extra layer of confidentiality. So anything that we talk about in those private meetings will be kept completely private, unless you specifically tell me otherwise. And so what I'm going to do is I'm going to start with Benjamin, and then I'm going to bring you back in, Morgan, and I'll have the same opportunity with you as well. And so we can have a little bit of a more frank conversation. Okay?
I'm going to try to mess with the camera while you walk out.
Yeah.
See if I can get it up there.
Okay.